Hi, I would like us to go through answering an AO2 criminal law scenario question that focuses on involuntary manslaughter. So as a reminder, what you need to do in the exam is achieve 25 marks and you have about 30 minutes to do that. You need to include 10 marks worth of excellent AO1, so that includes case examples that show your knowledge and understanding of the rules of involuntary manslaughter. Then 15 marks will be available for you taking those rules, for taking your knowledge and understanding and applying it to a given scenario. I want us to have a think about scenario questions. Generally speaking, scenario questions will probably have elements of both of the main types of manslaughter that the OCR specification looks at. So that is unlawful act manslaughter and gross negligence manslaughter. There is another type called subjective reckless manslaughter, but we don't study that for OCR. So generally speaking, a scenario will probably have quite a few things going on and will probably relate to both unlawful act manslaughter and gross negligence manslaughter. The way that I would recommend structuring your answer here is to deal with all of the AO1 first. And it's perfectly fine for you to do a heading to show the examiner that's your plan. Talk through the AO1 and then deal with the AO2 afterwards. So what is it that we're actually looking for? Well, I do think that we can separate this into 10 key points that we can try and memorise. First though, I would try and define involuntary manslaughter as a whole. So remember, these are offences where the defendant has caused a death. They have the actus reus for murder. Their actions have caused the unlawful killing of a human being under the Queen's peace. However, they lack malice aforethought, the mens rea. So perhaps they meant less harm than murder requires. Then I would go through the two different types. So I call unlawful act manslaughter UDAM for short, and the reason for that is because the D stands for dangerous. It's a really important part. So if you remember it as UDAM, fingers crossed you'll remember the whole definition. So how do we get those 10 marks? First, define the law. Really good way of starting your essay is unlawful act manslaughter is, or involuntary manslaughter is. Then the next key element is that it has to be an unlawful act. So this is an action, not an omission. Omissions cannot be part of unlawful act manslaughter. And it has to be a crime. So torts, for example, are unlawful. It must be a criminal action. Now, this is what we construct the manslaughter charge from. So you sometimes see this called constructive manslaughter. The next thing is it must be dangerous. The gauge of dangerousness is that it is dangerous according to the Church test, which asks whether a sober and reasonable person would foresee harm from their actions. So remember, it's not about what the defendant would foresee, but what an ordinary reasonable person would imagine. Then we need causation. And because it's the first time we're touching on it in this essay, I would break it down into both factual and legal. So factual causation includes the but-for test and having a clear chain of causation. Now, a special note I would make sure to talk about in the exam, if it has elements of drugs in the scenario, are the rules around drugs. And this came from the case of Kennedy. So if the defendant injects the victim, they have led to that death. The chain of causation is there and remains unbroken. However, if the victim takes the drugs and then self-injects them or takes them themselves, then that would be classed as a break in the chain of causation. This is because the victim has done an unreasonable action themselves that leads to the break in the chain. If you have factual causation, we also need legal causation as well. So legal causation is where we look at the remoteness of damage, and if relevant to the scenario, we would talk about the thin skull rule as well. So the AO1 must be relevant to the scenario. Finally, we need to explain the mens rea requirements, and the case of DPP versus Newbury and Jones says that all you need for the prosecution to prove this is the mens rea from the original lawful act in number 2. So that means you don't have to have any foresight of harm or death in this case. Now, so far we've not referred to any names. We have simply explained the rules. Then go through gross negligence manslaughter. So what are the key things to talk about here? Well, of course, we need to go with the definition. This is negligence, but it will be criminally prosecuted if there was gross negligence. The principles are similar. So if you understand negligence law, you understand gross negligence manslaughter. We need a duty of care. We need a gross breach, and that's decided based on the facts by the jury, and it must cause death. Now, there is no need to repeat all of the rules of causation because we've already explained them for unlawful act manslaughter. Now, the concepts here on this board are kind of generic, so you could memorize these and evaluate them in an essay or repeat them for a scenario, and you would just change the AO2. So the AO2 that we need to discuss, the first thing that you must decide in the exam is which offence is the incident dealing with. Is it potential UDAM or is it potential gross negligence manslaughter? How do we know what rules to start talking about? I think you need to ask yourself a key question when you're looking at the responsibility. Does it involve an act which is also unlawful? So straight away, if it's an omission, we need to go here because that's not an act. An omission is a failure to act. So if they have not done something when they really should have, or the law says they should have, then you need to look at gross negligence manslaughter. It may be an act which is not necessarily unlawful. So for example, it could be that the person has done something which they're allowed to do, but they did it badly and that led to the death. That would also be gross negligence manslaughter because they haven't committed a crime. So for example, a doctor may prescribe drugs which they're allowed to do lawfully, but they're the wrong type. So although giving them drugs is an action, it's a lawful one. They've just messed it up. So that too would be gross negligence manslaughter. So if they have committed a crime, then we need to be looking at unlawful act manslaughter. So how do we decide then if this person's going to be liable? First off, you've identified it's an unlawful act. Which unlawful act do you think it is? Is it battery? Is it assault? Is it robbery? Is it burglary? This is called constructive manslaughter because we're going to construct the manslaughter from this. So you need to find what's at the base, what's at the root of the crime. Then you need to consider the church test. So would a reasonable person foresee harm? Now, it doesn't matter if the people in the scenario did. I like to imagine a row of bystanders watching from the sidelines. What would they think? What would they turn to each other and say? Would they point out, oh, that might hurt someone? Then it would be objectively dangerous. If it is, did that crime actually lead to the death? And this covers the normal principles of causation. So first, the but-for test. We ask, but for the crime, would the person have died? If not, then they are the cause. If they would have died anyway, then it's not the defendant's fault. They're not liable. Then you need to check if there is a clear chain of causation. Is there anything that possibly intervenes between the defendant's crime and the victim's dying? Now remember those rules when it comes to drugs, if there are drugs in the scenario. Read very carefully. If the victim died from taking drugs, did they take the drugs themselves? If they did, then it's not unlawful act manslaughter. If, however, the defendant actually injected the victim, for example, or forced tablets down their throat or something like that, then there would be a clear chain. If here the person has taken the drugs themselves, I would just quickly switch to gross negligence manslaughter, because the case of R versus Evans did tell us about this. In Evans, there was no unlawful act manslaughter because the victim took the drugs herself. However, it was decided to be gross negligence manslaughter because her sister failed to call for help when she started overdosing. It was felt that she did owe duty of care because she caused the dangerous situation by supplying the drugs. So that's a way we can close the loophole that would let drug dealers get away with contributing towards people's deaths. We would then continue to decide remoteness. So was the type of damage foreseeable? Not necessarily how or how bad it will get, but was it foreseeable that type of harm would occur from those types of actions? And only if it's relevant, discuss the thin skull rule. So if that person normally wouldn't have died, but they did because, for example, they have an abnormally thin skull, that's tough luck for the defendant. They have to take the victim as they find them. Lastly, look for evidence of the mens rea. But remember, as we explained in the AO1, you only need the mens rea for the original crime that you discussed right back at the start. So they didn't need to ever contemplate that they might end up killing someone. It may never have crossed their minds. But for example, if they did intend to supply drugs, if they did intend to inject the drugs, that would still be classed as the mens rea. Always end with your conclusion. You must have a conclusion for levels 2, 3 and 4. However, if you've concluded here, don't feel like you have to do a big conclusion at the end. As long as you've decided each person is liable or not liable, you don't have to do an overall overarching conclusion at the end. If, however, you decided that the person just failed to act, or they did an action which they're legally allowed to do, or they were a drug dealer, the victim took them themselves, but then the drug dealer walked away and left them an overdose, for example, then look at gross negligence manslaughter. So, first off, did they owe a duty of care to the victim? So remember the situations where a person tends to owe a duty of care, particularly for an omission. So it could be a bit like Evans or R versus Miller, where they created the dangerous situation themselves and then did nothing about it. It could be that they have a special relationship, or that they have a they voluntarily took on a duty. So think of cases like Gibbons versus Proctor and Stone and Dobinson. It could be that person has an official or a special position in the community. So perhaps like a doctor or a police officer, they should have helped and they didn't. Or it could be a contractual duty. For example, a lifeguard failing to save someone who was drowning. So was there a duty of care? If there was, did they break it? So remember the tests that we use in civil law. It's simply a case of, did they fall below the expected standard? So did they not act like a reasonable person? So they didn't act like a reasonable doctor, they didn't act like a reasonable driver, they didn't act like a reasonable drug dealer. That's what we'd look at here. Check for causation. The rules are the same. A, B, C, D. Ask the but-for test. But for that breach, would they have died? Is there a clear chain between that breach and the victim's death? Was the type of damage caused foreseeable? And consider any thin skull issues if there are any in the scenario. Finally, and this is the big question for gross negligence manslaughter, yes, we've concluded they made a mistake. Yes, that mistake caused the death, but do we believe that mistake, that error, that breach was gross? Now remember, there is a circular test here. We decide if something is criminally gross by it being so bad it is criminal. How do we decide it's that bad? Because it seems gross to us. How do we decide that it's gross? Hopefully you catch my drift. Here, just to rely on common sense in the exam. Try and argue both ways if you can. That's always a really good way to handle it. but make sure you make a final decision as well. So it may be considered gross because, on the other hand, the jury might not think it is gross because. However, overall, I think the jury will decide this. This circular test really relies on common sense of the jury, but there were some guidance given in cases like Bateman and Misra, essentially reprehensible mistakes that are so bad that we shouldn't let people get away with what they've done, especially if it was quite a simple procedural error that could have easily been avoided, like in the case of R versus Adamaco. And yet again, conclude. So you need to work through, depending on what you think it is, the different potential crimes it could be, and then come to a conclusion at the end. If you conclude for each of the potential incidents in the scenario, you therefore don't need an overall conclusion. I hope that helps. Thank you for watching.